IPR policy has recognized that the business is global. The developments are going to be global, and therefore we need to on the IPR awareness or how to make use of IP for business. There we need to make improvement. But I never had this impression that to a particular sector or particular community, business or countries, it starts benefiting. I see it as well balanced in terms and recognizing that we are in a global environment and how we should be doing business. So I share a different view.
Actually, from the U.S. perspective, I heard talking, at the U.S. Chamber of Commerce and stuff, that it's the opposite. That it's actually more domestic looking than internationally looking, and people are scared there's going to be this big, nationally driven NPE for India, going out there and the government trying to get patents and start protecting or enforcing patents, and also, the need for kind of making India is creating more of a domestic acknowledgement of IP, which is great. But I think the thought was that it's the opposite. It's not really, pro-foreigners, so to speak. It's more of a trying to spur innovation and ideas in India more so than not in India.
So I'd like to comment on that. I think you're right. The question that I would approach that in one way, potentially, the national IPR policy can benefit foreign IP owners tremendously. Okay? There's a huge risk out there that it can. Why? Because who has the IP right now? Mostly foreigners. There's very little that are domestically driven. Okay? And national IPR policy is trying to encourage all the actors, judiciary, law enforcement agencies, businesses, etc., to respect IP. If that's the case, and if it's implemented incorrectly, a lot of money will flow out of the country as royalty payments. So it will can tremendously benefit foreign IP owners. Okay? And I think that's a very big risk that the government is taking, that they're gambling or they are hoping or putting their trust that if they do it correctly, and that's why in the other comment that was stated here, the national IPR policy is very inward-looking and directing a lot of effort towards creating the systems, the framework so that domestic IP can be created, okay? And true domestic IP, and not just number crunching where some of the other countries may have utility patents. So anything that's out there, you file a patent, you may not get it examined, but you've got a number, and then the government publishes that number and how it's got fantastic growth in IP filings and so on. And although the initial task force said we should have utility patents, the national IPR policy said, no, we're not going to implement utility patents as part of the process. But the national IPR policy is also talking about, the first section, talking about a lot of awareness and education. I mean, they're taking some very rudimentary and very strong steps by saying every single university in the country has to have an IPR course. It doesn't matter whether you're a National Institute of Design or something else. You have to have an IPR course. You have to have all your teachers trained on that. I mean, some of these rules that they're passing out are very fundamental to help create the awareness and to create a positive awareness about IPR. And then the final point in the IPR policy, they say that the policy must, I forget the exact, sorry, I don't have the policy in front of me, but there's something in there saying it's not just to support IP owners, but it also has to have a fundamental respect for, to benefit India in a balance. And I think that might have been targeting Raul's industry in terms of pharma and some other industries, where they're talking about that there must be a balance and not just for IP owners. But I agree with your question that there is a risk that it can potentially only benefit foreign IP owners, but that is a risk that the government has taken, and let's see how they implement that.
Yeah, this is a good point. Thank you, like a Vipin. I have from a different perspective. Let's look at this one here. Okay, let me just say this, and then I will turn it to SK. So here you look at this. For all these patent rule change, we have accelerated examination. This accelerated examination apparently is going to benefit Indian startup here. And they can get a patent very quickly, and then you go to the Delhi High Court. They can pretty easily to get a preliminary injunction. From this perspective, I think it's actually benefiting the local company. So I think if you think there's a potential benefit to the foreigners and there's potential benefit, if we're talking about this way, yeah, we can probably say it's a balanced act here. So SK, do you have any comments? Yeah.
National IPR policy is a very welcome move. But if you look at what happened around the same time, CRI guidelines which spoke about novel hardware requirement, e-filing of working statements. National IPR policy is a fantastic positive thing, but at the same time, you are having other policies which are contradicting the national IPR policy. So when you say that you want to have more domestic filers, and IT being, software development being the power of this country, you're saying we don't grant patents for software and there is a requirement of a novel hardware, right? They seem to be, you're closing the gate on Indian industries, right? How will we achieve that objective? My only concern with CRI guidelines is the novel hardware, the requirement of a novel hardware. And of course, e-filing of working statements was discussed at length. So when I have a vision, all the other things has to tie up to that. But we don't see that happen. But national IPR policy is a fantastic move. It's a very welcome move.
Can I add one?
Let's make this one as a last comment.
Yeah, just one comment adding to what SK just said, because if the objective of the national IPR policy is also to enhance domestic filings, then again I see some conflict with some other sections of the Indian Patent Act, especially in the pharma industry. Because when we look at domestic filers, at least in the pharma industry, most of the Indian companies are into incremental innovations, because basic research is, let's be honest, it has a lot of investment, and most of the Indian companies would not invest into core basic research. They would only look at the compound in pharma and try to have something over and above it. Now, we have this section 3D of the Indian Patent Act, which is focusing only on these incremental innovations. So having both at the same time, they're actually going to, it's not going to fulfill the objective. If national IPR policy would want to have more of domestic filers, then section 3D is an impediment to it. So that's the point, and this is also in line with what SK is saying, that maybe in high-tech industries is similar. Similarly in pharma, there has to be some support, some collaboration in all the policies.
Okay, thank you. Go ahead. Yeah.
One of the pillar is most favored nation. The another pillar is the national treatment, and the third pillar is the market access. This is what the WTO applies for all its members. India being a member of the WTO. So national treatment is one of the fundamental. Most favored nation is one of the fundamental. Market access is one of the fundamentals. So having reliance on the WTO criteria for all the WTO members for which India is, and under the TRIPS agreement also, the same principle of these three cardinal principles applies for all the WTO members. So therefore, if anybody has made any such comment that this national IPR policy is more in favor of the foreign filers, I think there may be some misconception, misunderstanding, but there being some apprehensions in the mind of the foreign filers all the time that the Indian IPR regime is not in tune with the global IP prosecution and other requirements. So national IPR policy is to give a message to the global community that India is for innovation, because the Prime Minister has given a statement that India wants to transform, so transformation through innovation. So through the Make in India drive, all these things are done. So this could be part of the publicity, that national IPR policy is giving a very transparent platform to all the MNCs who are filing in India, but this is not biased. This is a national IPR policy. So nobody can term it as a foreign IPR policy. It's a national. So it's national in its spirit, means it is equally without any discrimination to either party, whether it is a foreign filer or Indian filer. This is just I wanted to summarize. Thank you.
Thank you. We actually open to the audience for questions and comments.
I'm TPS Parmar. So I'm senior consultant with Lex Service now. I was just hearing to what Mr. Agarwal has said, and I was also hearing to all the people who are talking about IPR policy. And I was also hearing about 3D. I was also hearing about working, and also hearing about the amendments. I have few observations which just I want to convey. Being a member in a public, you must be open. And whenever we are talking about patents we disclose. I'm talking about amendments. You start filing PCT application and they're published. Once you publish the applications, public has access to that. And they know in which area I'm working. My area is now fixed. Then you start making amendments. First amendment, second amendment, third amendment, fourth amendment, fifth amendment. How far a person will chase you? Which is the final thing you're going to obtain a patent for? So it's always better. You first file whatever you want to take the patent for and leave public to understand which area, which is my area where I can freely operate. You cannot change stance every time. So amendments are okay, fine, no problem. Your amendments are to the extent what you have disclosed to the public. But once you make the changes in the claim, you are changing the scope. You are just trying to either reduce your scope, and public who is also seeing what exactly are my freedom to operate. It's not you, because when you sit on the other side, when you are not a patentee, when you are opponent, you also face the same problem. Because if all people start making amendments at any just top of a hat, then what? We must stand on a firm ground for a particular period of time. And patent law allows you to make amendments at any time after the grant also. You can amend whatever you want to amend, but not at the initial stage. Just on the gate you want to just make the amendments. And when PCT says one application for all the countries, means same application should be applicable. Yes, when you have the ISR with you, some reports have been adverse to you, of course, you can make the changes. And these changes are again published in PCT before you enter the national phase. And whenever you enter the national phase, you are facing the pre-grant, post-grant, and so many oppositions. But people should know what I am opposing. So that is my observation for shifting how many amendments you can make. As far as deletion is concerned, yes, this is a good step. And I agree with you when you said that, yes, whenever I am not interested, I must be allowed to delete the claims. There's no harm in allowing the deleting claim. And when we are talking about working, we are in a system where we are serving the public. If you are inventor, you are saying, yes, I'm working the invention in the public. And if you are not working, you say, I'm not working it. So that public will know. Which is the place public will know? Patent office. If patent office is transparent enough to inform the public that this gentleman is not working the invention, what is the harm in it? If not working it, so that they can approach you. Simple policy is there. They can approach you to grant them the licenses. Of course, if he has the capability to do it, he will approach you. If you are working the invention, you can give some information. And information which you will give, definitely you are saying that it's very difficult to get the information, how much money I am earning from my patent, or how much drug I am making. Yes, of course, because you may be working in so many locations, and difficulty is there. But that difficulty is not that far that you cannot look into it and see that the public knows that how far you are working here. Because we are granting you a monopoly, we are granting you a patent, and we can ask you how much you are working in India, so that what benefit India is getting from the invention you have been granted for. So that is the question which I just wanted to make it. And third and fourth observation which I want to make it is relating to as you said, it's helping the foreigners. I also agree with him. It is not the foreigners. We are helping everyone who is an inventor. We don't recognize we just recognize inventor as an inventor. We don't say he with any nationality. We don't put any nationality to inventor. So inventors are always welcome, whosoever is there, and we encourage them. And when IPR policy is made, it's just to encourage innovation, inventors, and its exploitation, and also the enforcement part. When you are looking at the enforcement part, definitely we are looking at the system, whether the system is in place or not. If the system is in place, as he said, somebody was saying that, I just heard him that you can have an accelerated examination, you can have an accelerated grant, and you can accelerated injunctions. So when you have a system in place, how you use it is a different issue. So the system is in place. That is what TRIPS also says. You must have a system in place which provides a transparent, fair, and equal treatment to all. That's enough. If you bring the human factor into it, that some people are getting injunctions, some are not getting injunctions, some is not getting, case-to-case basis. You cannot bring all the things at one place and say, okay, no, everyone should get injunction. Because at one point of time, you may be the opponent when injunction came on you. Because now it's a free for all place where you have to work. I agree with you, certain concerns are there. That has to be addressed.
And I appreciate your comments. Sorry to interrupt you. We are 7 minutes after already.
I just made last comment.
Yeah.
I appreciate the concerns you have shown, and some of the concerns are really good, and we should look at it too, and let us see how we can proceed further on these issues. And definitely, we are looking to build a system which is globally acceptable.
Yeah, we can leave this as an offline discussion here. We can discuss this a lot. I think we have to close up here. I really appreciate everybody stay so long here to listen to our talking here. Hopefully it's useful. I think overall we see some welcome signs. India is making some good progress, and national IPR policy is good. I'm not saying we are saying what we are saying here. There's still room for improvement. I think these comments can apply to any country, right? It's not only to India, yeah. So, and I think we as an industry should work together. For example, how to make this process even better. For example, how to reduce the applicant's burden for this working statement. I still say working statement. I don't think I fully understand what you're saying, but I do hear you say like working statement is easy to ask an inventor to do that. But for a company with thousands of patents, identify these inventors. Some inventors probably is gone already. Even for inventors, they probably don't know whether this one is getting into the product or not. So I think still, let's just work all together to make India is even a better place to protect IPR. Thank you, everybody, again. Yeah. Okay.
Hello, everyone. I just have one question. I'll not take much time. As per the working statement says you'll have to define the number of units and the rupees or the money. Number of units to calculate is very easy. We can calculate, but the amount is very difficult to calculate. But anyhow, there is no option. We'll have to file the statement, and it's still a burden. But the second critical issue that we face, being an IP in-house counsel, is that there is a very thin line in trade secrets and filing of a patent application. Now, trade secrets are the secrets, but when the employee shifts to the other company, the trade secrets is void again. So, should we file the patent applications for that basic components or not? Relating to the IP experts, in-house counsel, what process or the proceedings that you follow?
Anybody want to respond here? It's.
See, when IP is getting generated, or when we make IP strategy, of course we look at, is this something, this subject matter like what we have, is it something suitable for patent, or is it something that we should keep secret? If it is determined as keep secret, of course, in company, most times, the rights are transferred to the organization. So, so it's the company which is filing in most cases as the applicant. The rights from the inventors are transferred to the company. The same thing happens also for the trade secret. So persons must be made aware that, look, we are treating this particular subject matter as trade secret, and it's important that we keep this confidential, and that has to be respected. So, of course, there are shades which would start coming in as unknowingly you start employing certain things, and that's a risk which a company has to evaluate, like what's the right strategy for this subject matter. Is it better as patent, or should it go as trade secret, where we are willing to take the risk or keep that clean, where the diffusion over time has not happened just because people shift from one company to another. So managing trade secret is not an easy thing. Managing patent is much easier that way. Thank you.
I think we really need to stop here. May I just suggesting something? This is a really huge topic. We should suggest it to the controller of patents to create a project. We can assign this project to Professor Viping to research that, the benefit, and then give us a recommendation. What should we do? Okay, thank you, everybody. Yeah.
You spoke at the time for a few seconds. You should be there.